Hello and welcome to another episode of the Immigration Podcast. My name is Rob Ratliff. I'm an immigration attorney here in Cleveland, Ohio, and a former immigration judge. With us is our co-host, Susan
Susan
Miller.
Miller.
Yeah.
I'm a retired former Department of Homeland Security prosecutor and also an attorney in the Charlotte area.
And today we have a very, very special guest. Go ahead and introduce yourself.
Everyone, I'm Tania Nemer, and I'm a former immigration judge as well.
I dare say that we are the only podcast that has three. Well, no, Tania will be our fourth former immigration judge. So, welcome.
I think you're doing a great job. It's great to hear all these perspectives.
Yeah, welcome. So,
Wonderful.
yeah, so let's start out with a little background. Tanya, tell us a little bit about your time as an immigration judge and where you were at and what your thoughts on the job were.
So I was an immigration judge for almost 2 years. I was appointed under the Biden administration, and I loved it. It was such an honor to serve as a judge, especially in immigration court, because there's a lot of lives at stake. And I think the reason I say it was an honor is because you're here to help America be better, right? To make sure we're following the law, to make sure we're really listening to the testimony and the facts and the evidence. And it was really just a great experience. I had great colleagues, very smart individuals, and we often would talk about how would you handle this case and what do you think about this. And it was a great office. It was wonderful, and I was very sad to be terminated not just in the way that it was, but that it happened that way. I was the first immigration judge in the United States terminated. I was on the bench, on the record. I had about 30 immigrants in my courtroom, DHS counsel, and I was escorted out of the building from the bench without being told why. I still, at this point, the only thing that was ever given to me was a decision in an administrative appeal that said, we terminated you because we can terminate you. Under Article 2 of the United States Constitution, the executive branch has the power to hire and fire anyone regardless of their race, nationality, gender. And so we can fire you because you're a woman. We can fire you for whatever reason we want to. So now this case is pending with federal district court. I do believe Title VII protections do apply to federal employees. And the great news is I'm not the only case right now. So there's other judges who have come up the pipeline who have also filed similar suits.
Tanya, can I ask a question on that, Rob?
Yeah, definitely.
It's just shocking to me as a former, government attorney. Not shocking that under this administration, but just if I were to you said you were on the bench.
I was on the bench. I don't even know if I turned off the record. Because
I
was told to get up,
the public. This is done in front of government counsel.
Everyone.
You said.
Yes. Actually, the attorney who was in the courtroom with me, I worked with at the Summit County Prosecutor's Office. He was the DHS counsel at the time when I was pulled off the bench.
Where was this?
Cleveland, Ohio.
Cleveland. Wow.
Yeah.
And did the government counsel know what was going on?
No. Nobody.
So everyone's just has no idea what's going on. They just.
No. You know what's funny?
Did you have an idea, or did you feel like
none? No, none. I mean, the chief judge of the entire United States was located in Cleveland. He was in the office next to me. We shared a wall. As I was being escorted out, I asked to speak with him. And so his office is like right by the exit. And so I stopped in and I said, do you know why I'm being terminated? And he's the chief judge of the entire United States. He's like, I have no clue why you're being terminated.
Did he really?
My administrative judge said, you're one of the best judges that we have. I have no clue why you're being terminated.
Wow.
Yeah.
Wow.
And then I later figured out why. I mean, at the time they were only terminating women. they've actually only hired white men to fill my
Yep.
spot.
True.
Um,
Yep.
they 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 clearly have issues with. I'm a dual citizen of Lebanon with Arabs and Lebanon, right now. So, um, and
Oh, I believe in my heart of hearts, based on everything going on, that you were
yeah,
definitely targeted for that too.
yep. And I was the only one who had run for judge as a Democrat. So it's very clear I,
Yep.
was a different party affiliation at the time. So,
That's a hat jack violation.
yeah, yeah.
Yeah, it was, and I'd already returned to Cleveland. I was back in private practice, and I'd appeared before you as a defense counsel, I think, a couple of times
You
by then.
have, yeah. And you
And
did an excellent job, Rob.
well, thank you very much.
Well, good job.
Yeah, I mean, it was, I think, nationwide, but definitely locally, it was a very shocking incident because it was right at the beginning of much of what was going on with the current administration and discharge of judges and things of that nature.
It was the first. I was the first. Like
Yeah,
with 700 judges, you picked Cleveland, Ohio. I was also the lowest paid judge on the bench. So um, it's weird they picked Cleveland, me
But
of all. But
you know what? It's not if you really dig into the
I
Epstein.
agree. You're right. You're right. It is.
It's something about
At
Ohio.
first, it felt that way. Like, why me? Why Cleveland? But then when you started realizing what was going on, you're like, oh, now I see why me.
Right. Epstein files kind of go right to Ohio and the
That's it.
Rockefellers, and I didn't know Ohio was that important until the Epstein files.
Yeah, right.
there's a lot of connections to Ohio politically. I mean, just the number of presidents, not recently, but the number of presidents from Ohio, the Taft family, the Rockefeller family. Um, Ohio's had a fairly important role. And even now, Judge Riley is now the chief judge.
So you have another chief judge from Ohio. So
Yeah.
the one when I was there
Wow.
was was living in my hometown actually, and then they picked another one to take his place, and she's the Cleveland
Yeah.
judge.
They went through a couple of interims, and then it was Judge Riley. I ran into her in the hallway one day, and because I hadn't seen her on the bench in a while, and she was acting ACIJ for a while, assistant chief judge here in Cleveland, and I think Cleveland and Detroit, and then next thing you know, she was chief judge, and then the
Wow.
Judge Comans, who I worked with down in Louisiana, is now, like, I think her title is like director of policy or something like that.
Oh, I don't think I
So
knew
they,
that.
those two have risen very quickly. But Judge Riley was on the bench for a long time, a U.S. attorney, and I don't know what her political opinions are, but she definitely went all the way to the top. And again,
Yeah,
from Ohio with that Ohio connection.
yeah, and she's a really hard worker too. So I mean,
Yeah,
there's that. But it was very quick how
yeah,
she stemmed from a line IJ to a chief judge, but she had worked hard all her career. So
yeah. And she was with the U.S. Attorney's Office, and regardless of their political persuasion, I tend to think that former U.S. attorneys do a
yes,
very good job as immigration
Yeah,
judges.
most of them. Yeah.
Yeah, just because of the trial experience, and in federal court, I do a lot of federal court defense work. It's about resolving cases, and Tanya, you work right now in that kind of role. It's about resolving cases fairly and responsibly and quickly. That's why there's not a lot of trials in federal court.
mm-mm.
Mm.
And so they bring that same mindset. I don't think, and Susan, you're a perfect person to ask this. I don't think that resolving cases mindset that comes from like criminal courts exists as much in immigration courts. Definitely not as much as it used to in the 90s.
Not under
And not
this
in Cleveland.
Yeah, definitely not in Cleveland.
Definitely not.
not under this administration. I mean, I worked under about 5 presidents, because when I started with INS, And for those of you out there who don't know that, it's Legacy Immigration and Naturalization Service. In 97 as an attorney, when I started then, working through Clinton, Bush, Obama, Biden, Trump, it was Obama that seemed to be the one resolving most of the cases. Most of them, I mean, there was some under Clinton and sometimes under Bush, it depends, but mostly Clinton. I think they wanted the adjustments when I was in Boston to be done more so if we could get them done by INS, we might dismiss them and let them do them in front of INS. In front of examinations unit, but we did them so quick in court that, most people wanted to do it in court.
Well, and that's one of the issues with the massive backlog now is, I don't know, I haven't seen any of the directives, but the impression I have is DHS attorneys are being told specifically not to settle cases, not to agree to fight
Right.
everything. And, that's contrary to clearing that backlog. I mean, if they would talk to us and communicate like you would in a criminal courtroom, I think a lot of cases could get resolved in one way or another. But now we don't even, and Tanya, I don't know if you know this, but, we used to get the assigned DHS attorney list. So you would know who was assigned to what judge like 90 days out. And so you could email that DHS attorney and say, hey, I have a question about this case, or can we agree on this number of witnesses, whatever. And they don't do that anymore.
I did not know that.
Yeah.
If you call the duty attorney, will they tell you, or they're actually refusing to tell you who's the attorney?
Sometimes they're not even able to tell us. And, that's another issue at Cleveland. There's no duty attorney email. You can call them, but,
Yeah.
maybe you get through and
they don't answer it anymore a lot of times.
Really?
Yeah. So like in Charlotte, so I worked in the Charlotte office last as a government attorney for DHS. And I know the policies, but the policies completely changed after I retired and left. They let me give you an example. So generally that day, if you write to the duty attorney, they have to get back to you that day. So they may not have the answer that day, but they need to acknowledge the email.
Yeah.
That they received it and that they'll get back to you. And that duty attorney that day is assigned to answer it, even if they can't get it done that day.
Yeah.
So they still have to stay on top of that. But now, if I write the duty attorney, they don't write back. Now that's Charlotte. I have that duty attorney box. They don't write back anymore. If you call them, well, you don't even know who the duty attorney is anymore because you don't get like Rob said, you're not getting a list. So you don't know who the duty attorney is.
And they're not answering. So it doesn't matter.
They may not be answering because, when I was even during COVID times, we were allowed to stay at home. And then there were times when we finally had to go back in, but at a certain time in the day, you may be allowed to leave and go back home. So, and they're not giving you a government phone. So you don't have to answer the phones. And under this administration, I think I believe that they told them not to agree to anything, to deny everything, to appeal everything, which under Trump 1.0, we were being told to do. We were being told to appeal everything, which was, we don't have time for that, but it didn't matter. It was all about making everything as difficult as possible for the respondent's counsel, and trying to win everything, even if it didn't make sense to me. One, it didn't seem fruitful. Two, it didn't seem worth our time or our resources. Yeah. But now I think that they're trying not to answer us. They're trying, and here's the difference, right? If I didn't answer someone before, I could get in trouble. Meaning that, there
are consequences.
There are consequences. Your boss will talk to you because then the attorney will complain. Now they're being told, I believe, that you don't have to answer them. So now they're not going to get in trouble for not answering. So why are they going to do that extra work of answering the phone? Because I'm sure there's some of them that don't want to have to say no to everything, but they have to. So they probably don't want to have to hear it because it probably hurts their heart. You know, and there's still some good people there.
Yeah. I mean, and that's so contrary to like what a prosecutor is. Me working at the prosecutor's office from the day one, I was told our job is not to win. Our job is not to put people in jail. Our job is to make sure justice is served, to ensure justice. And so we could ensure justice and lose a case, right? Like, let's just say someone didn't, we found out evidence that they didn't commit the crime or what happened. Well, that means justice is served and it was a success. Sounds like what they're doing is just saying, we're going to win. We're going to cut all communications. And our goal is to just make sure they all lose and they get deported. Yes. Justice and the law has nothing to do with any of it, I guess.
Yeah. And I think there's even another level to it of just trying to make things as difficult as possible. I think we've seen it in EOIR now with, I don't know, Susan, if you've had any just hyper technical basis for rejections of filing.
Everything you can imagine.
Yeah, how bad is it since, and I think that was Riley who issued a memo to the judges regarding the denial of these applications even before they're being heard? Are they like really nitpicking?
Yeah.
Everything.
Yeah. Really?
Yeah. And
like, give me an example. Just curious.
Okay. No, I have one.
I don't think you can win anything in court, really.
Well, I have one just from earlier this week that we filed a motion for bond, then we filed a separate supplement evidence for the bond, and my fault, but in the certificate of service for the supplement, we put the foregoing bond motion, so it didn't say bond motion supplement, just said bond motion.
Yes, yeah.
So the bond motion was filed and the supplement was filed, two separate filings. They rejected both because the certificate of service in the supplement didn't say bond motion supplement; it just said bond motion. So,
are you serious?
Yeah. So the bond motion should have still been filed and docketed
because it had the right service certificate.
So, but they rejected it. So, yeah.
Well, did they reject that one based on the fact that there was no supplemental evidence?
No, they rejected both filings. Like, they wouldn't accept them
just because of the certificate on the one.
Because of the certificate on the one. So, I mean, it was a 30-minute delay because we file it, we get the rejection back, and we just fix it and send it back. But it's just one of the, if it would have been a pro se individual,
oh my God,
they
don't stand a chance.
They've been at a loss. And I don't know how pro se individuals are filing anything now. I mean, when I was a judge, I was at a detained docket, and the people that were detained had no access to translators. They had very little access to anything. So getting things filed was difficult for them. So I don't know how they're even accomplishing it now. And they've done away with the advisors, the nonprofit group that was.
Yeah, they did that while I was there. I'm just curious, when you were on the detained docket and you saw how hard it was for someone detained to do these filings, what was the denial rates for the detained judges in these detained dockets?
But you know what? It's incredibly high. It's like 98, 99%.
Which makes total sense. They don't have access to justice, right? They don't have access to filing, so the denial rates are going to be higher.
But I think it's
too fast paced too. I can't.
That's true. Yeah, that's a good point.
I can't do an adequate job for them.
Yeah. Well, I think one of the reasons though those detained docket denial rates are so high is because if it's a really good case, if it was someone that had legitimate claims, didn't have a criminal background, they were getting bonded out. So they were making bond even when they were filing pro se bond requests. Many people would get bond
when you were a judge.
Yeah,
but now.
Well, yeah, now a lot harder. And so, anyways, I think the historical denial rates in the detained dockets are somewhat inflated by the case selection that ultimately go to trial.
If you realize that some of the people that are, majority of the people that are in detention wouldn't have been there in the past. Like the people I've come across have very good cases. Either trafficking visa cases, labor trafficking, human trafficking.
Yeah.
Almost all of them have that, actually. They just don't realize it. And, one has a cancellation of removal application that he's eligible for, has U.S. citizen children. But, based on his detention, and see, they don't have money too when they're detained.
That's the other thing.
There's no income.
Well, and plus the cost for an attorney, like a legitimate cost for an attorney to take a case like that, because it's so fast paced and you have to put your other cases on hold.
Exactly.
Is very high. Like, so even if you were working and you had money, you can't, it's a lot of money.
It's a lot of money. And the people that are willing, like, even if they have friends that are willing to try to help them out, the friends, the third party person will come to you and say, well, what's the guarantee that you can get them out? They're more concerned about getting them out first, or what's the guarantee you can win? Well, there's no guarantee whatsoever, and there's no percentage. They ask the percentage, and there's no percentage, especially in this reality. The reality today is, if they're detained, I wouldn't say that, but you don't have as much of a chance. It's just the truth. Because, for example, there's a judge down in that deals with Louisiana. She's stationed out of Texas, I think Houston, one of those regional adjudication type centers for the judges. Yeah. And she's denying everything, absolutely everything. I overheard a case when I was waiting to do a bond hearing, and this is what was shocking to me as a former government attorney, especially now that I know how the new agents and officers are trained. The government attorney, DHS counsel, said the I-213 said that the respondent was previously removed. Well, the judge said that's not true. Based on the records that the judge had, the prior case was dismissed. Well, she was pro se, and DHS counsel said, well, we object to voluntary departure. She just wanted to go home. We would object to voluntary departure because she has a prior removal. And because the woman did not want to wait, the judge said, well, we can wait for the government's file for them to prove that. And you'll sit in custody. This is what was said. You'll sit in custody, or you could take the removal order. So she took a removal order. The consequences of that, even though she legally should have been given voluntary departure, the government couldn't prove there was a removal order on that day. And yet she gets a huge consequence. And I found it incorrect for the judge to do that. I mean, just listening.
And was it a hearing? Was it a voluntary departure hearing that day where they should have been submitting all their evidence regarding the
well,
so
it was a bond. I mean, it was a voluntary departure hearing because my bond hearing was after that. It wasn't. I don't think it was a master. I didn't see the docket, so I can't tell you. But
yeah, but they should have their evidence submitted.
The government never has their files anymore because they stopped ordering them. When I was there, they stopped ordering them, so they don't have a file. And what bothered me so much is just because something is said in the I-213 doesn't make it correct. Correct. Especially with the way officers and agents are being trained these days. They don't even know
what being trained.
Yeah, right. Exactly. Because I used to teach at the Federal Law Enforcement Training Center, and it used to be about a 6-month program, not a 45-day program. So yeah. I don't think an I-213 is inherently reliable anymore. And
I agree.
I've seen things. I saw something with one of my clients that said that they were arrested and convicted for a crime they weren't arrested and convicted for. And DHS would not stop saying that was true. And I even had a judge deny bond saying the person was convicted of that crime when I had the dismissal right in front of me. And she refused to take the dismissal.
Wow.
Yeah. So yeah. I guess my point is, in detention, it's very difficult, and there are people in detention that shouldn't be there.
Well, and that's, one of the biggest issues I thought with many of the people that were detained was not only the lack of translators, but just the lack of literacy skills. I mean, there's a lot of people that just can't read and write, and even those that maybe can read and write, they can't read legal text and fill out.
Oh, yeah.
Some of these forms have to tell me, like, wait, what is that asking? So, I mean, that was even a further complicating factor of it. And that's, I don't know, Susan, how often you get solicited by the latest and newest AI-based immigration help tool. And, that my last question for every one of these salesmen that calls me is like, all right, but
oh yeah, I do. I get those emails.
How does it work for someone that can't read and write? I get it. Maybe this works great for a doctor applying for his third H-1B, but not somebody that just got here and can't read or write the language.
So at and I'll just say, like, I'm speaking for myself in my own personal capacity here today at the podcast, but in my work, I notice AI has helped a lot of people, pro se people, file cases against the government. It's interesting what AI has been doing. Do you guys see anything right now in immigration court? Has it been helping at all? Anyone file anything or submit the proper evidence in any way?
What I have seen is more people coming to me, with a preconceived idea of, hey, I think this is what I want to do. I think this is what I can do. I think this is what I'm eligible for. And sometimes they're right.
Okay.
And so, but the AI does miss a lot of nuance, and it does miss a lot of the older things. The people, especially people that have been here for a long period of time. The rules have changed while they've been here. So knowing, like, look, based on this date, these types of things are possible because maybe you're eligible for this that somebody today wouldn't be eligible for. So I find that it misses a lot of that. And even when I use some of it for research and try to, look for cases, what's very helpful is, like, I know there's a case that says this, but I can't remember the name of the case. And that's like the hardest thing to find. It's helpful for things like that. But the nuance of comparing timelines and things, it just doesn't pick up on.
Yeah, I agree.
And I don't know how, like, 30 years from now, like I've been practicing about 30 years, I guess. And so I know that AI is wrong because I have 30 years of experience.
Right.
30 years from now, I don't know how somebody will know if AI is wrong, and we'll probably just all accept that, well, no, it's AI, it must be right. So
I agree. That's why I don't even use AI, because I know that there's even the new attorneys don't even understand the laws from like 1997, IRA correctly. I mean, I was there when it was implemented, and that's why the whole arriving alien with the whole EWI and detaining them, I knew it was incorrect because I was there when the law was created. I was there. I was training new attorneys on that. So if I'm training new attorneys for INS on what the regulation what it actually meant and how we interpreted it as well, 30 years later, they're trying to change it. I think that type of experience is going to be lost in AI.
Yeah, and they're trying to change it not legally, not in the legal method.
Right.
And we're seeing more and more of it being implemented in the processing at USCIS, in the paperwork processing, and how we know some of it's going on is because there's been programs and things that DHS and USCIS use where they've terminated using them. So we know that they're using other forms of AI.
What did you say? They're terminating?
There's been reports on types of AI that DHS and USCIS have used in the past, and they say we're no longer using this because there are problems with it. So
they're rejecting applications they shouldn't have, or sending back, saying there were pages missing and the pages were there.
Yeah, and I've had numerous of those, and RFEs on routine kind of business transactions that ask for certain documents that, it was Exhibit A. It's right there on top, which
Right.
kind of reminds me of the old days when they used to have the mail rooms and the contract mail employees that would, the paperwork would come in, and it would just get shuffled, and then when it would come back to you, you're like, wait, this is not even what we said.
It's funny, Rob. When they send it back, they actually send it not even in order now.
Yeah.
And
Yeah.
it's like, there's page 4 right here. It was in order, and now it's down at the bottom. And
Yeah.
you're saying there was no page 4.
Yeah, and I don't know if you remember, but back ALA used to have like on the listserv thing that you can go in. There used to be like a whole column for people that got somebody else's like notice in the mail, and you would post, "Hey, I got a notice from this person and this A number. Whose is it?"
Yeah.
Just the common mistakes that they would make. So, yeah.
Susan, I am curious a couple of things. What is what did you see the difference between in administrations from your perspective on the government side of things, like how each administration handles immigration? I mean, and you were there for a big change of law. Like, how did that go down with changes?
Yeah.
How do people respond to that? And how did a leader help that response or not help that response?
Yeah. Okay. That's
It's a
great
big question, but like I'm
No, it's
listening to your
great.
talk and I'm really curious.
So if I go back to the beginning of my career, it was so much smoother. So, going between Clinton, which Clinton passed some really tough laws, IRA,
Mhm.
and ADEPA.
What did you guys think of it at the time?
Well,
just
I was
curious.
so this is the thing, because I was young and didn't really understand the world. I didn't have a child at the time, didn't understand hardship as much. As a middle class, white woman that just graduated law school. So you have to take that into perspective and realize that I was just gung ho to be a prosecutor at the time. And I didn't like fraud, and I didn't like if people lied. So for me,
We still don't.
yeah, I was, back then in Boston, especially Boston, I came from New England, and I was probably one of the toughest prosecutors. And me and my friend Helen, we were tough, but that's because we really did our job cross-examining. So I didn't realize, like, now I look at it and I'm shocked that it was Clinton that signed those laws into place, because I didn't even realize the lifetime bar, because we weren't implementing that back then. We did not even, I don't even know that we were trained on the lifetime bar. Like,
Wow.
now, I really don't, not way back then when it first came out. So now we had a lot of people who, they didn't leave and come back. They just had a lengthy period of time. They might have had a removal order and had it reopened. So maybe that's why we didn't see the lifetime bar part of it. But anyways, that between Bush and Clinton, it was pretty smooth. The only thing that was really different is that I think they kept going back and forth about this six, like S is in Sam, I is in intelligent, X is in, I don't know how it's coming out on here, as in X-ray, 6 Sigma lean strategy for workforce. And that was a little scary. That had nothing to do with actually the new laws. That was more about, are we going to implement these pay bands? And whether or not you're going to, instead of having our natural step increases. But other than that, the actual law, people were fine with it. During the Bush administration, everyone kept thinking that, there was going to be immigration reform. So that was constantly talked about. In fact, immigration judges were fine with actually continuing the case an entire year, because there was chatter about immigration reform.
I mean, but wasn't this essentially a sort of immigration reform? I mean, this was a big change in
Yeah,
law.
but Bush was going to do something to help people until 9/11 happened. I don't know if you remember that, but
yeah. And
Yeah,
then he did something way different, right? Like,
because the
was there
public
like
was
those
like,
registrations on everyone
right,
who's Arab and like all this stuff I remember.
because they got us all scared. Like they brainwashed us
Fear.
very well that September 11th was committed by a certain group of people. There are a certain group of people we should be scared of. And we didn't have all the facts. And so, you know, I mean, I think they did a really good job with, MK Ultra and me to believing that, working for the government. So we
Yeah.
focused the registration we took really seriously. Yeah, it was, they definitely brainwashed us very well to go after Muslims and Arabs. And that's what we did in Boston. I worked in Boston. I worked in New York. I worked in Charlotte. It was my last duty station for court-wise. Then, okay, transitioning over, so Bush and then to Obama. And now when Obama came in, I actually went to teach at the Federal Law Enforcement Training Center in Georgia and then in Charleston. In Charleston, I taught the 287G program also. So I didn't get to see what was going on in court until I came back to court in Charlotte. And I found that really interesting because I'd been away for 6 years from teaching and from while I was teaching. And Obama was doing the prosecutorial discretion.
Yes.
And so that was a shock to me, because I'd come from, the whole after 9/11, we became Homeland Security. We were gung ho. We thought we were saving America. And unfortunately we were, a little too gung ho, obviously, because that's really what we were told. And then, 2007, I'm down at the Federal Law Enforcement Training Center. And then in 2012, I'm in Charlotte. So I found that transition hard for me because I hadn't been there yet in that position of we're spending more time looking through cases of which ones not to prosecute. Why I just felt like, why doesn't ERO, the enforcement removal operations, just send us the cases? Why don't they sift through them ahead of time? And
That's a
then
good thought. I mean, you're right.
And then we spend less time. Like we'll still work through cases and work out, okay, well, maybe this one shouldn't go forward. But we wouldn't be spending them sending every single case, and all we're doing is going through all of them to kick them out.
Yeah.
So that was interesting. Obama's second term, I will say in Charlotte, the attorneys there are the ones when I started with were very aggressive. They were like, probably, I don't know what I was like when I was younger to look back. I hope I wasn't as aggressive as they were. I don't think I was as, I think I spoke very kindly though. So there's some prosecutors that they're aggressive and they don't speak nicely to counsel. At least I know I was nice to everybody, even when I was younger. But the ones I work with in Charlotte were extremely aggressive and, not a little abrasive, I think, to the opposing counsel. And they did not like the prosecutorial discretion. And because of the leadership that we had in Charlotte, which a lot of them ended up going when Trump went up 1.0, they went to the Trump administration, they went to ICE, they went to Oakland headquarters. So it kind of tells you they're more, Republican, more MAGA. And so
more politically,
yes.
they were they were more promoted, I guess, for their
they were promoted, but they did not like the Obama policies, and they got a lot of phone calls to headquarters on them, and they had to learn to comply. So I saw that. Now during Trump 1.0, they loved it. The leadership in Charlotte loved it. In fact, I was very uncomfortable with it because they started having us go after DACA kids. And interestingly, they take the most empathetic person in the office and they give me the DACA kids, and they want to keep them locked up. They want me to appeal the bond. One girl had a DWI, but she had graduated from high school. She'd been here her whole life, and
she's still qualified for DACA.
She qualified for other relief. I think she qualified for she. I don't know if she was convicted of the DWI, but she probably was. But the conditions were pretty bad.
Yeah. Okay.
Now her case, I understand a little bit more so on the bond, but the other kid, he had a trespassing, and all he did was he went in to go see his baby, and he wasn't convicted, and they wanted me to appeal that as well. The fact that the judge granted bond.
How does that feel? Like, I think about that, especially now in this administration, and if I were to have stayed, right? How did that feel for you, knowing that this person really didn't do anything wrong? There was no conviction. And under the law, like, we really needed that conviction to justify that sort of imprisonment, right? For however long he was in.
Right.
And we'll say prison because a lot of them are, but
especially
after Obama, but
these are county jails they're being held in, so right?
Yeah, or federal penitentiaries in Ohio. Yeah. So how did that? And I'm asking, not judging, actually, because I have a lot of really good friends who are in this situation right now, and I would have been had I not been terminated. I don't know what the answer is. How did that? What to do with that? There's not just a legal conflict, but there's also an ethical conflict. How was your work environment into that situation, and how did you survive, and how did you get through that?
That was extremely difficult. In fact, it was extremely hostile work environment because of it, because the majority of the people in that office were MAGA. And they had Fox News on in the lunchroom, and you couldn't change it. And
so politics was very prevalent, is what you're saying.
Politics was obvious. We had one person come in with elephants all over her dress for the election, which I think is a Hatch violation, but she was friends with the boss, and she ended up going to headquarters during Trump 1.0 with the boss. So, it was, what was really difficult was I actually tried to advocate. I guess the word isn't advocate, but I tried to explain to the deputy chief counsel who was, making me appeal that bond that, he wasn't convicted. His sister testified for him. He went in to see the baby. The mother of the child's not testifying against him. She hasn't contacted us. She has no interest in this. And, what danger is he?
Yeah.
He was like he's like a kid. He was like, 18, 19, 20-year-old kid who went in to see his child. And that's very immature, but you're talking about the most emotional thing possible. Your children.
You're still thinking about it, actually, and all the details.
Yeah, I'm still thinking about it.
And I think clearly the entire system has become more politicized, for good or for bad. But don't you think that that's the way it is set up? Going back to the Constitution and, authority being granted to the Attorney General and things like that, it's almost like it's set up to become this political back and forth with these large swings that don't really help anybody and don't really create any consistency. It's almost designed to be chaos.
Well, that's what I hated. It became a political football. When I started, people didn't really even know. I didn't really even know what immigration was. I fell into it in 1992 when I was in college at Boston College, and is an
That's actually
internship.
pretty early and pretty impressive that you
Yeah.
fell into that at that young of an age.
Yeah. In 1992, there was an internship when I was at
Wow.
Boston College. So, and I had no idea there was an immigration. I didn't even know what immigration law was, but who really did back then, unless you, I
Who
mean,
did do that? It was you.
yeah. So I didn't even think about where I came from, like how my
Yeah.
family came back then. So I took that for granted at that time. But um, yeah, I guess it just became a political football after 9/11 too. Everyone knew what immigration was. It became a political football. And it's very hard. Normally as judges, you guys, you, particularly before this administration, you still had independence, like to some degree. I know you had pressures, case numbers and case goals and case completions,
Right.
but you had judicial independence. As long as you kept your temperament, you could rule I think, right?
Yeah. Oh, yeah. I felt I had judicial autonomy. I never felt pressured to rule one way or another on anything.
Yeah,
You're right.
as
We
long
did
as,
have numbers, and we efficiently had to get through these cases. Um, and there was pressure there, but it didn't, that pressure doesn't sway. That pressure is for completion, and it could be completed to
right,
grant or deny, but like it was never for a specific decision.
right. And that's what I love because, whatever you thought was correct, the judges, you know, you were just doing your job. And, sometimes it was a little quicker. I could tell that comes sometimes when during certain administrations, I'm like, oh,
Yeah.
I mean, it
That
was
that towed the line of like, are we giving due process when we're limiting
right.
the amount of direct and cross that you can complete and the amount of time you have for a hearing,
Yeah.
But
And that's even more constrained now. I mean,
yeah.
Yeah.
90
It's
minute
hard.
Tell me,
hearings.
I hear now they're like 1 hour for
Yeah.
the whole trial. Is that really what's happening?
It's
There
worse.
are some. Yeah, there are some. And we're routinely, they're getting scheduled in 2 hour blocks, but sometimes even 90-minute blocks. Other courts I've had. So,
Are they completing it? So when I was there, they would do the 2 hour blocks, but then you'd continue it because you didn't get through it because our DHS like
yeah.
really would cross examine for a very long time on very like I often would say like where's the relevancy here, but I always wanted to make sure I'm hearing all the testimony, and so you give it patience and continuances to allow them to complete all of them to complete their cross and direct. So the 2 hour block was there, yes, but there would always be like a continuance. I'm hearing that they have to get it done within a certain period of time that day and issue the decision that day. And I don't know if that's true or not, but that's kind of what I'm hearing.
Probably.
I've heard that as well. I haven't had a trial where I felt like the judge had forced it to conclude
Okay, good.
that they
That's very good.
would, but I have heard from others that, especially if there's not attorneys involved, that these cases are being uh, very narrowly constrained and tell us your story, all right, get out of here, kind of thing. And that's it's alarming in the pro se cases. I mean, and I always felt it was like your duty as the judge to not just tell me your story and go from that, but to drag out that story to say, all right, these are what you need to. This is how you prove an asylum case. Do you have anything that meets this? Do you have anything that meets
The
that?
extra detail to comply
Yeah,
with our obligation to provide a full and fair hearing. And pro se's don't know what that detail is, and so we have to handle it with extra care to make
yeah,
sure we pull those details out and see if they comply with the law, right?
right. Because otherwise, you just well, what happened, and they don't know what is important and
That's
relevant
right.
in their background and story under U.S. law. They just feel persecuted or threatened or whatever it is. So yeah,
Right.
I felt that was a duty as a judge in those detained pro se cases that you to do that. I don't know. I haven't obviously seen a pro se
They're not doing that.
trial. but
they're not doing that.
yeah.
In fact, I have a case that I picked up after another counsel had it, and they asked the client if she wanted to appeal right after the decision, and I believe that they actually stated to her, every day that you stay here, you can be fined $1,000. So if you choose to stay, like if you appeal and if you don't appeal, you're going to have a fine for every day.
Yeah.
You don't actually file the appeal.
You have to stay in prison.
Right. So she said she didn't want to appeal, but then she did. And I filed the appeal. I didn't know she said she didn't want to, but she still had the 30 days.
Yeah.
I filed a notice of appeal. Do you know, they said, nope, she waived her appeal at the hearing. She had the 30 days. You can't. And not only that, I mean, the decision was really bad because they said, the judge said that she couldn't have been raped because she didn't have any evidence of it. It was in a dark alley, and she was gang raped in India in a dark alley. Like, where you? How many rape victims have witnesses in the first place? But the decision was ridiculous when I read it. I mean, if the judge wanted to find it didn't meet the threshold for persecution somehow, but to find that she's not credible on something that probably happened to her based on my discussions, I think that's overstepping it. But
Well, on that happy note,
sorry.
kind of summing up on an hour, Tanya, anything you want to talk about in your situation these days?
Yeah, well, so the good news is I'm running for judge in Summit County, and I
Yes,
am
Summit
hoping
County,
to get back.
Ohio, Akron.
Yeah, in Ohio. I'm hoping to get back to the bench, and we're just trudging along with that. There's so much going on in the immigration world. I have been keeping up, and I have been keeping in contact with attorneys and judges that I worked with, and it's just it's really heartbreaking to see the breakdown of the judiciary in this way. And I hope to be elected so that I can be a part of the judiciary and make sure that, the things that we talked about, people have full and fair hearing, due process, that justice is you might not walk out happy, but at least you were heard. And so I hope to do that. And I hope the more we keep talking like this and the more we keep doing, as you all are, the more improvement we can make and the better it could be. But it is disheartening, and but if we're quiet about it, then we're not going to make change. So, and that's why, Susan, I was asking a lot of these questions between administration. So, because this is not political, like the judiciary should never be political.
Shouldn't be.
It's different leaders with different agendas, and how do you navigate that? And how does immigration, like as a whole, get better? And your knowledge, I mean, all of you, your knowledge is very important to change right now. So thank you for what you're doing and being here and having me here. It's really, I appreciate it.
You are welcome.
It's such a pleasure.
Yeah, you are welcome anytime. If you just want to complain about something, send us a text and we'll
Yes.
Yeah, that's how it works anyways, I think.
I mean, this is the point of podcast. I mean, and it's great because it's July 3rd. Tomorrow is the 4th of July. It's a holiday we're all going to honor, and that's why we're here. I mean, justice is part of our country, and
Yes.
fairness and diversity. And so it's going to hopefully be a great holiday where it will continue to encourage us to do the work that we're doing.
Absolutely. And thank you for everything that you did.
Oh, thank you.
I'm sure you affected lives in a positive way, and you did your job.
That's the goal, right? That's the goal.
Yep.
Yeah. All right. Well, thank you guys, and we'll see everybody on the next one. And
Thank you.
like and subscribe and all that fun stuff. And here we go.